Your Honor, I believe my client's on screen now.
Okay.
Richard, would you state your name for the record?
Richard Allen Bass.
Thank you.
Okay. All right. So today's the date and time set for all three defendants' motion for an in-camera review of records pursuant to People v. Stanaway. So I've had an opportunity to review the combined motion as well as the people's response. I'm happy to hear any highlights from any of counsel who wish to, but how do you want to proceed?
Your Honor, if I could just highlight a couple of things, and then if anyone else would like to jump in afterwards.
Okay.
The court knows that one of the defendants had previously filed a similar motion, and the court, to be fair, had denied that motion. I think the court said that there were no specifics in front of it, at that time to really make a determination on. And so now I think we're in a little bit of a different position, Your Honor. The defendants, through investigation, have uncovered documents that the complainant has a pattern of making false and bogus claims against caregivers in her life. And I say that they're false because there's been no investigations after she's made those allegations. There's been no charges or anything like that. And we do know that she is in therapy, and that she's in therapy through the same department where those allegations against other caregivers are made. And so we believe that it's logical to assume that the complainant was herself pushed in therapy on details regarding the allegations that she's made here. And so we believe there's a reasonable probability that she had made statements about untruthfulness in her claims against the caregiver in this case, Your Honor. And I know the court's read our written brief and motion, so I can leave it at that. Thank you.
Okay. Anything to add before we proceed, Mr. Goldstein or Mr. Killowell?
Yes, Your Honor. If the court wants specifics, and Mr. Bernstein did include some in his written document, in our written documents, and also in his oral presentation, but credibility is not just in that very narrow question of, for example, contradictory statements, although there are a number of those in this case, including the victim allegedly saying that she's never been sexually assaulted. But credibility is even broader than that. And in this particular case, we also have a victim who tells people that she hears voices, which certainly goes to the issue of her credibility. The only way this court can make a determination whether the statements are relevant and therefore discoverable by the defense would be for the court to review those records and make a decision. But simply to accept Ms. Reiser's claim, well, they're not relevant, they're not discoverable, it really is not giving the defendant rights that they have to due process.
All right, Mr. Killowell?
No further statement, Your Honor.
All right, Ms. Reiser, I've had an opportunity to review your response, but if there's anything you'd like to respond to directly, I'm happy to hear it.
Just briefly, as I indicated in my response, Your Honor, the court rule and the case law is very clear that there must be demonstrated a good faith belief grounded in articulable fact that there's a reasonable probability that the privileged records are likely to contain material information necessary to the defense. And assertions that privileged documents may damage the credibility of a witness does not meet that threshold. And that's People versus David Christian, 316 Mishap 204. And I don't believe that there's been anything other than that asserted here. There's an allegation to a medical provider. We don't have a date. We don't have a location. That she said she wasn't sexually assaulted. And the other attacks are on her credibility. So we're asking that the motion be denied.
Okay. All right. Thank you for your briefs and everything that you filed. It's very helpful to have the thoroughness from both sides. Matters before the court on defendants, what we'll call the People versus Stanaway motion. People v. Stanaway is a Michigan Supreme Court case that governs whether and under what circumstances privileged records are discoverable by the accused, where a defendant can establish a reasonable probability that the privileged records are likely to contain material information necessary to a defense. An in-camera review of those records must be conducted to ascertain whether they contain evidence that is reasonably necessary and therefore essential to the defense. A generalized need to attack the credibility of the witness does not establish the threshold showing of reasonable probability. Here, the court agrees with the prosecutor. All the defendants have cited to is a statement that the complaining witness, a 6-year-old at the time, sought aid from a counselor and that she may or may not have declined to report a sexual assault. General allegations that the complaining witness is untruthful is subject to cross-examination, but not a basis to access privileged records. There is no reasonable probability established that the complaining witness made exculpatory statements to her therapist. A generalized need for her privileged records is insufficient and defendant's motions are denied. I do need to take up one matter though with Mr. Richard Allen Bass. So that's case number 22044 FC. We were in court recently on June 27th at a hearing, on a motion hearing, and Mr. Allen Bass stood up after the hearing and said to the court, I'm going to give you 2 quotes, "Y'all are straight bullshit," end quote, and also, quote, "suck my dick." That was on the record, and I find you in contempt of court for those statements. That is what we call direct contempt of court, made in the presence of the court.
I wasn't talking to you. I wasn't talking to you. I wasn't talking to you. I have freedom of speech and I wasn't talking to you. I was not
advisement.
Richard, just be quiet.
I wasn't talking to him.
So,
I have freedom of speech. I wasn't talking to him.
Okay, so I'll take that sentencing under advisement.
Judge, I didn't hear, I'm sorry, I didn't hear what you said.
You didn't hear what I said, is that I'm finding the defendant, Mr. Allen Bass, in direct contempt of court for his statements before the court. I will take his sentencing under advisement.
Excuse me.
I don't care. Take it how you want to take it. I can have freedom of speech.
Hey, my attorney, can I see you today?
We'll talk, Mr. Whitsett. Now it doesn't feel like the right
Yeah,
time.
that's what I'm saying. Can I see you today?
Your Honor,
Thank you. Mr. Bernstein, do you want to prepare the order or do you want a separate order from each attorney?
I'll file it, Amy. Okay, I got it. I'll do it.
Thank you.
Your Honor, as far as my client would still like to have a bench trial in this manner, I believe that's what he wants, Your Honor. And so I know we have a trial date coming up in September, but
Well, you've got all of you have a same final pretrial date. It's September 7th, I believe, because we switched the docket days. So that's going to be on the Wednesday instead of the Monday. So that's the, I think all 3 of you have a final pretrial on that date. So Mr. Kilwald, if your client wants to waive to bench, we can obviously make a schedule at that time.
I want a bench trial. Let's get this out the way. And I have freedom of speech and I wasn't talking to you. I will sue y'all. I promise you that.
Okay, Richard, I appreciate that. But anyways, Judge, we'll see you on the 7th. And again, we're going to ask for a bench trial.
Okay, sounds good.
Okay, what about Goldstein? What about my lawyer? Goldstein, where you at?
I'm gonna sue the fuck out of his ass. I don't give a fuck, nigga. I got freedom of speech. Fuck what you talking
Goldstein,
about.
where is David Goldstein at?
Got me fucked up.
Hello, Your Honor.
So attorneys, do you want to keep the Zoom hearing going while your clients are just talking at me, to me, or do you? Anyone else have anything to say?
No, thank you. And the people are all set.
Okay, thank you.
All rise. The Washington Trial Court is now in session. The Honorable Patrick J. Conley Jr. presiding.
Good morning. Please be seated.
People versus Patricia McDaniel, 2246 FC.
David I. Goldstein appearing on behalf of the defendant.
Okay, Ms. McDaniel, can you hear us? If you can hear us, Ms. McDaniel, raise your hand. Okay, well, I don't know, other than this is the date and time set for Mr. Goldstein's motion to withdraw as counsel. I'm gonna let Mr. Goldstein speak for a moment, Ms. McDaniel, and then Ms. Reiser may have a response, and then if you want to say anything, you can, and then we'll go from there. So she did raise her hand, so let's presume that she can hear us, and then she can move closer to the mic if she needs to. Go ahead, Mr. Goldstein.
Thank you, Your Honor. I filed a motion, very briefly, going back to the original trial in this matter, what we call the Alan Bass trial. Just before the trial, I indicated to the court there had been a breakdown in the relationship with Ms. McDaniel. The court actually, I believe the court heard a tape of a phone conversation between my client and her mother that Ms. Reiser provided to me. At that time, the court did not allow me to withdraw. I went ahead and did the trial. Obviously, Ms. McDaniel was not happy with the results of that because it was a conviction. And since that time, she's indicated, one, that she does not wish me to continue as her counsel, and that number two, her mother, who was providing me the resources to defend the matter, indicated that she no longer was able to do that. So I filed the motion. I did serve Ms. McDaniel, I believe, on a prior hearing, although it was not on this motion. She did indicate verbally that she wanted me to withdraw.
Any response, Ms. Reiser?
No, the people will leave it in the course discussion.
All right. Ms. McDaniel, is there anything you want to say about Mr. Goldstein's request to withdraw? Initially, I had some further reluctance to allow your withdrawal because of the proximity of what's going to be the second trial. But given the circumstance of needing to proceed with this evidentiary hearing, I don't see any prejudice to Ms. McDaniel in terms of allowing you to withdraw. We're going to have to adjourn these matters. So the question I would have is, Ms. McDaniel, if you can speak to this, do you intend to hire another lawyer or do you want the court to appoint one? Okay.
Your Honor, she apparently can hear us. Why don't we suggest that she get one of the officers, one of the COs to help her? Maybe they can make the microphone work. There she goes.
Good idea. Well, apparently at MDOC, you can just wander about. While we're waiting for her, just if you, sir, if you could just.
Can you hear me now?
We can hear you just fine. Thank you so much.
Are you all set?
Yep. All right.
Okay.
Ms. McDaniel, you don't have any objection to Mr. Goldstein withdrawing, correct?
Correct. I do need him to get off my case.
Okay.
And I need my money back.
Do you intend to hire a lawyer or do you want the court to appoint one for you?
No, I need a court-appointed lawyer.
All right. And let me ask everybody in the room, I'm guessing the public defender is not an option. We've cycled through that. And so now we would be looking to somebody on the list. Is that correct? Do you remember? I mean, these cases kind of.
I presume they would. I'm trying to think who's representing the children abuse and neglect.
Well, I think they had Ms. McDaniel originally. I think the public, and that's why Bob Killawall was appointed for Alan Bass and why Sam was appointed for Withdrawal, because I think they had, public defender had her originally.
It's not really her term.
Right.
What?
The assigned counsel manager knows that Mr. Goldstein, the situation, and they're getting ready to appoint someone.
Okay. I mean, it would be easy if it was the public defender, but we could just, so Ms. McDaniel, I will appoint representation for you, and then that person will be in touch once that happens, okay?
That's it?
All right, that's it. I'll sign the order. Thank you.
I'll present it, Your Honor. I don't have the file with me. I'll present it to you tomorrow.
All right, thank you.
Thank you.
Okay.
I'll see you soon.
Hey, Goldstein! Wait, Patrick! Patrick!
Pretrial, like leaving 3 weeks out or something, so I can better again.
Yeah, why don't, well, let's see, so yes. I mean, so Ms. McDaniel, we're going to set a pretrial so that after you've met with counsel, we can kind of see what happens. We'll probably set that out in early August, I think. Because 4 weeks is I'm not going to be here. So we'll do that like that first Wednesday of August.
Mr. Conley.
August 2nd, pretrial. Okay, thank you.
At what time?
You're done. See you back here on August 2nd,
All right, what time? You don't know what time?
1:30. Yep. And your new lawyer will be appointed by then. Okay?
All right.
People versus Robert Whitsett, 2248 LC. Good morning, Your Honor. Amy Reiser on behalf of the.
Good morning.
Good morning, Your Honor. Sam Bernstein here on behalf of Mr. Whitsett. I don't see him on the Zoom screen yet.
Mr. Whitsett, can you hear us?
Yes, Your Honor, I can.
Okay. We're here today, Mr. Whitsett, on your motion or your motion filed by your attorney, essentially notice regarding intent to, I don't know if this is the right word, pierce the rape shield, but rape shield notice and motion to admit evidence. I've reviewed that. I have also reviewed the people's response to it. I reviewed a number of cases, the preliminary examination transcript. So I guess I'm just going to put out there kind of what I understand today is going to be. And if I'm wrong, feel free to correct me. But defense seeks to introduce evidence of the sexual conduct between the defendant, Alan Bass, the relationship of that with defendant Daniels, and then the minor child, the victim. Seeks to introduce a number of different theories. One is that the minor is doing this. I'm just summarizing, so don't take offense if I don't quite get it fully. But one theory is that this is some sort of retaliation against her mother, who's the defendant, co-defendant. Secondly, that the prior convicted defendant was an abuser or abused the minor child more than once, and that the minor child is confusing the co-defendant in this case with the defendant, co-defendant in the other case. That there's some theory that, again, the minor child wishes to hurt this defendant, Whitsett, similar to how she was able to hurt the other co-defendant. And then there are other, I think, quote, plausible defense theories available. So that was my attempt to summarize what the motion contained. My read of kind of the proceeding today is that the defendant is obligated initially to make an offer of proof regarding the proposed evidence and to determine its relevance, or make that offer of proof as to its relevance, and that if it is relevant, i.e. probative versus prejudicial, I make the decision moving forward on there. But in the offer of proof, if it's not sufficient showing of relevance, then that would be grounds for the court to deny the motion. So there are other remedies potentially available to the defendant here in terms of, and the victim actually, in scope of cross-examination. I deny the motion. There's also remedies available to try to allow relevant testimony in, maybe through parties other than the victim in this case. I mean, obviously, this is the right to confront, and it's a critical right. But one thing I am considering too is, again, in reflecting on the prior trial, I'm not clear, and I didn't go back and rewatch any of the prior trial, but I'm not clear as to whether there was confusion or conflation in the testimony of the victim versus the potential of the police investigators testifying about both defendants and how that may have played into this. I'm just giving you my thoughts and reflection on that for you to sort of consider it in your argument here. So that's kind of where I see us today. I've also gone over the preliminary examination transcript, so I didn't watch that video, but I've read the transcript and read the testimony of that as well. So, Mr. Bernstein, fire away.
Yes, Your Honor, I have a number of things to say. I can preface it with, I have watched the trial videos quite a bit, so I'm pretty familiar with what everyone in the video testifies and in the trial testifies too. So I might mention that. The court is right. At the initial outset, I need to give an offer of proof and demonstrate relevancy. I'm going to right now kind of add a little bit to what was in the written motion now that we're here for an evidentiary hearing. Kind of walk through some of my thoughts on it. So, the situation presented, Jalela initially makes a disclosure about Richard Allen Bass. And that disclosure is that mom and Richard Allen Bass engaged her in an act. She then goes on to speak of this disclosure to several people in her life, including Andrea Bonner and some other CPS workers, police. And then she eventually goes to a forensic interview where she speaks about her disclosure regarding, I'm just going to refer to it as Richard Allen Bass. Richard Allen Bass. Now, throughout that entire process, though, there is no mention of Robert Whitsett. The first time that Robert Whitsett's name arises is like a week or so after that first forensic interview, where she only discusses Richard Allen Bass. So just as a starting point, before I get to more offers of proof, I think the lack of mention of Robert Whitsett, is relevant from, just a credibility standpoint. For example, if it happened, why didn't you bring it up throughout this process? Now, I think as an offer of proof, I would expect the argument to be that Richard Allen Bass committed a horrible assault for which he and mom were convicted at trial. And I might refer to those, if I refer to those as allegations, that's only because in like the story of the investigation, they remained allegations until they were convictions. But certainly they are convictions, and they're jury convictions too. So it's been proven beyond a reasonable doubt. And, Robert Whitsett can argue now that that is like a fact that has happened. Going from there, Jalela has made this disclosure about Richard Allen Bass to a lot of people in her life. And from there, her life changed. And I think the expectation is that her life changed for the better. She is secure. She's getting attention. She has lived her life with her mother, who has neglected her. Jalela says that she doesn't love her mom. And, she has gained some security here, and she wants to continue that security. And after that initial disclosure, she's realizing that her life can change for the better. And that can be an argument that Mr. Whitsett can make at trial. There is a requirement by case law that the instance of sexual assault be similar to the current allegation at trial. I did lay out all those similarities in my written motion. So I won't, if the court wants me to go over all those similarities now, I could, but the similarities are fairly great. Finally, as a third,
I don't need to put them on.
I get it. Yes, Your Honor. As a third, offer of proof, as everyone else in the room knows, has been through the trial. The two investigations, Richard Allen Bass and Robert Whitsett, are intertwined in a sense that the process of going through the disclosure of Richard Allen Bass eventually segues into the disclosure of Robert Whitsett. In watching the trial, it seems like every single witness talks about Robert Whitsett at the trial of Richard Allen Bass in connection with the investigation. There were witnesses who only spoke about Robert Whitsett. Detective Kopic only spoke about Robert Whitsett. Detective Babich spoke mostly about Miss McDaniel's statements about Robert Whitsett in detail. And then I saw Elizabeth Burry, Terrence Crowell, and Officer Lewandowski all mentioned this other, the other disclosure, the other allegation, the other claim about Robert Whitsett. These were all prosecution witnesses, and they all spoke about it. I think preventing Robert Whitsett from bringing up the investigation, the assault and conviction of Richard Allen Bass would effectively prevent him from cross-examining about the investigation into himself. And cross-examination about the investigation is a part of every trial with a criminal defendant, and should be just a bedrock right of someone who is on trial. I think the big question for the court is how we do this, and I know the court has said that a couple of times. How do we get there? Really, I can speak about Richard Allen Bass really for the most part through every other witness other than Jalela. Every other witness has already testified on record about that. They were all a part of it. They all know about it. And frankly, that's like the extent that I need to get into it. I don't have to examine Jalela in a lot of detail about going through that trauma. A lot of the rape shield policies and law is designed to protect privacy, to not embarrass or humiliate or anything along that line. I think it's painfully obvious that the defense would gain nothing from beating up a young witness about something else that happened. I think that would send my case into a nosedive pretty fast. And when I go to trials, I'm trying to win the trial. So I'm not going to engage in, the type of actions designed to shame Jalela or unduly embarrass her. Frankly, I think you can expect a lot of empathy. That's the way to go about it. So, unduly there's not going to be like a play-by-play cross-examination of like what happened between Richard Allen Bass. That's not what I anticipate at all. And if it comes in all these different ways, I think we have to bring up that she made another disclosure. I think, her testifying about that, is important. I should be able to ask her, so you made this other disclosure is about another person. You went through a trial, that person was convicted. I don't think that unduly harms her, that type of questioning. She has gone through this process already and has kind of put it out there, and all these other people have put it out there. So I think I anticipate that the examination would mostly be left at that. And
let me interrupt you.
Sure.
Sort of, this is really, not that everyone in the world needs to be interested by this sort of thing, but this is kind of the fascinating thing for me, lawyer too. It's not an absolutely isolated application of rape shield, but it's an unusual one. And I appreciate that you're sort of putting it out there that in fact, most of this question can happen through other adult witnesses that are, I want the process to protect the process. I want to protect your client's rights. I want to protect the people's rights. And so I guess what I'm saying to you is, okay, that's a relief. But what I'm going to sort of anticipate with Ms. Reiser is, again, a specific response to that, because I do believe one of the protections in this case could be to limit this cross-examination of Jalela. And to the extent that you're sort of offering that could be something we could work on prior to the trial. I'm not foreclosing Ms. Reiser's rights to argue the validity of rape shield, even as it applies to third-party witnesses or investigative witnesses. I'm not saying it's not a very effective tool or an important tool. But in this particular case, I am most concerned about, this little girl. So I'm not most concerned about her relative to your client, but in the context of what we're arguing today, that's what I'm worried about. So that's what I'm going to be looking to Ms. Reiser, kind of response. Is that a way to have the trial play itself out fully, whatever that means, and not impact, again, the consideration of the minor child? So again, none of that is to sort of imply that, in my opinion, the minor child's rights are superior to your client's rights, but it's the process of the trial that worries me. And then this also gets into, as we've said, and as I've been wringing my hands about when you've been at the bench, the complication of a double jury trial and how are we going to manage that with Ms. McDaniel's rights as well as Mr. Whitsett's rights. So go ahead and continue, but I just want, while you were on that topic, I'm
Sure. And I think I sort of made all the points that I had been hoping to make. And just one thing I just want to highlight, just the importance of being able to discuss these topics. There was a first trial about Richard Allen Bass. It was not about Robert Whitsett, but Robert Whitsett's name did come up a number of times. And they were prosecution witnesses, so they came up sort of on offense, right? He was mentioned, and that was used to convict the two defendants. And now it's Mr. Whitsett's turn, and he wants a fair trial. And when it was, used against him, I mean, he as just a matter of fairness, Your Honor, wants to be able to do the same thing just defensively. And I do think that case law supports it here. And I do think there's a tactful way to go about it. And I'm sort of giving the court my word too, just a gentleman's agreement that, I'm not here to, this won't be a cross-examination where the butcher knives come out talking about this other instance and going super far into it. I don't think that's necessary. I don't think that's helpful. And I think Mr. Whitsett knows that that's not helpful, and that's not.
Assessment of how that looks to a jury is probably pretty accurate.
Right. So I think there'd be, I guess my point is a lot of self-regulation just by the circumstances that would be at play too. And that self-regulation would virtually certainly keep what I would do in line of what would protect the process from the standpoint of what the legislature was trying to achieve in creating rape shield notices and the unusual circumstances of here, while also, in being able to cross-examine this, protect Mr. Whitsett's ability to confront his accusers, confront the investigation against him, and have a meaningful defense as well. So I can let Ms. Reiser speak on the topics.
And Your Honor, I think as I indicated at the bench previously and in my response, that we're not far off from our analysis here. When I think of the rape shield and try to apply it to a victim who was 7 or 8 years old, it's a difficult concept. And a lot of what the case law that Mr. Bernstein and I have cited has talked about are circumstances where it's inadmissible under rape shield, under People versus Hall. Some circumstances may exist when the evidence would establish that the complainant's bias, ulterior motive for making a false charge, or that the complainant has made false accusations of rape in the past. And People versus Williams also addresses that. And the Hall court also said that this court has opined that the evidence of a young complainant's prior exposure to sexual abuse may be admissible to establish age-inappropriate sexual knowledge. But unfortunately, what the case law addresses is not really what Mr. Bernstein is alleging in this case. He's not alleging that she has age-inappropriate knowledge. There can't really be a defense that there was a false accusation, because the perpetrators of the prior assault have been convicted. So, but when we look at, so that's and it also, I have to concede to the court and to Mr. Bernstein that the investigation is so intertwined that Jalila was placed in foster care in January 2020 and January 2021. I have to go back and look, for an abuse by her mother, a physical abuse, and didn't make the disclosure until that summer. And when she made the disclosure to her placement, Andrea Bonner, and to the CPS worker who was working on the case, and she was forensically interviewed, the initial disclosure was about Richard Allen Bass. And that did come in the Richard Allen Bass trial, and also the fact that 2 weeks later, she made a second disclosure when she was asking for her money and what Rob and her mom had done to her, Rob. And so the investigation, then a second forensic interview was conducted. So I agree 100% that even in Mr. Whitsett's trial, we don't get to the forensic interview where she discloses the sexual assault by Robert Whitsett without talking about the initial disclosure with Richard Allen Bass. So I think what I would ask the court to do, and in the Williams court, when it talked about citing People versus Hackett, and the defense is obligated to make an offer of proof with regard to the proposed evidence and demonstrate its relevance to the purpose for which the evidence is sought to be admitted. I think in this case, the relevance is that the investigation was an initial disclosure about Richard Allen Bass, and then the second disclosure about Rob, mom's boyfriend, Rob. In talking about that, they were actually analyzing like a false accusation, which of course we don't have here, but it talked about the trial court has the responsibility of restricting the scope of cross-examination to prevent questions that would harass, annoy, or humiliate the victim and to guard against a fishing expedition. And I don't think we would have a fishing expedition here because we know exactly what's in the pond. We know that there's a conviction. We know that she was sexually assaulted by mom and Richard Allen Bass. So I think that the evidence does have to come in because we also don't want to restrict the defendant's right to confrontation. But what I'm saying to the court is let's follow that guarding of him cross-examining Jalila, and the information that would come into Mr. Whitsett's trial would be that Richard Allen Bass and Patricia McDaniel were convicted, not that there's allegations. I think the information comes in that the convictions happened and she did testify about them.
Like, how do we do this? I have plenty of experience, but I've not had this particular issue come up pre-trial where I am, seeking to work with counsel, both of you, to restrict the scope of cross-examination, because again, the defendant has the right to confront, and depending on what the answers to some of those questions might be, they may generate other questions. So I would be looking to the two of you in further pretrial discussions as to how we actually, and I would be looking to for some guidance from you on that. I'll be thinking about a lot myself before the trial. So I think then, again, I'm less concerned about the investigators and their examination, Mr. Bernstein. I mean, for lack of a less sort of offensive way to put it, they're big boys and girls. They do this, they're police investigators. They can stand up to direct and cross-examination, and I'm not super worried about that. We do have the jury management question so that's kind of is the protection for the victim under the Rape Shield Act, is that idea of harassment and humiliation, and cognizant of age, already now testified twice to this. But I'm also, as I've said, very concerned about the juries. and now that Ms. McDaniel doesn't technically have a lawyer right now, I'm probably more concerned about her jury situation in terms of what is disclosed and what comes out than Mr. Whitsett's, because, again, that I think it'll be fairly straightforward that these are not allegations that they were committed. But I am worried about what her jury hears, and we have to be careful about that. So to the extent then that I think I needed to hold this evidentiary hearing for the record, because I don't want a situation that whatever happens after trial, there's an appeal and the trial court didn't follow the necessary steps. I'm satisfied that I think then that I can probably grant the motion, the defense motion, preliminarily order that there will be restriction on the cross-examination of the victim in this case. And then we can work out the details of that in the pretrial proceedings so that we're at least prepared for whatever we can be prepared for. Things happen, and I'm not going to say we're going to anticipate everything, but so that's kind of where I'm sitting today.
And I think there's also a jury instruction that, and we can craft it and tweak it regarding, you'll hear testimony of another trial in this case. So we can sort of tailor that to Mr. Whitsett's trial.
Okay.
In my proposal, and I think we can sort of parse this out once Ms. McDaniel gets an attorney, presuming that her attorney will object to her conviction coming in, obviously, but that if the either her jury is excused when that testimony is anticipated, or an exhibit is admitted of their convictions only to Mr. Whitsett's jury and not to Ms. McDaniel's jury.
I mean, I think that those are just some logistics. As like I have no desire to try this 2 more times either. That process probably for each of them better, but we're obviously trying for the witnesses and all that. So those are all the things that we're weighing here. So to the extent that as far as what's on deck for this morning, I think clear. So I will grant the motion as to, again, I'm not going to grant it, So when I sign an order, like additional plausible defense theories, like that's pretty vague. But as far as, seeking to admit evidence through testimony of the investigation that involves both Mr. Whitsett call, but also Mr. Alan Bass, I think does make some sense given that kind of the fact that they have been so intertwined and how that's going to work. So I'll sign that order. We'll set a pretrial in Whitsett and McDaniel's case for that August 2nd?
Perfect. And then I would just ask Sam, are you going to prepare the order? I would just ask that the order also include the language that the convictions are admissible.
Right.
So it's kind of like an all or nothing.
I'm fine with that. Yeah.
But I would 2 things. First, perhaps the court could tell me very specifically what to write down in this order. I just want to make sure I got it right.
It's not like I've seen a million orders in this particular thing. Your theories are that, again, your theories are your theories. That the reason that Jalila said what she said had to do with her mother, had to do with, this other stuff. I don't know that you need to get in particular detail in the order about your theories, but that in fact, there will be, the convictions are admissible, that the discussion or the presentation of evidence, I kind of liked how you said it actually, was that, Mr. Whitsett has the same right in his defense to argue the same things the prosecution did in this case. You don't have to put it quite that way in writing, but I think that essentially you're allowed to cross-examine, the investigating officers or any other witnesses, whether it's Bonner or, anyone else, in terms of what those disclosures might have been and how that was related. And that, even if frankly, the court will limit the cross-examination of the minor child, in a manner to be determined pre-trial or something like that. I don't know. I'm kind of making that up for the first time sitting here.
Okay. Fair enough, Your Honor.
So August 2, well, I guess just use that as kind of a status conference. We don't have a date right now.
Your Honor, I was hoping, praying that July 10th would be our date. I mean, Mr. Whitsett has never been given a true trial date at this point, and I do share in some of his frustration. He was given
I'm not unaware of that, but you have to, I mean, the stakes are incredibly high in this case. I mean, I can't divorce my own knowledge that there was a conviction in the other trial. So so now, your client may be innocent, may be guilty. I have no idea. But I would say that the risk of flight for me in assessing your client's case is exponentially higher now that there's a conviction of the co-defendant. I have no idea what that means in terms of his own trial. And frankly, I'm completely unaware of the evidence and his test, or the other testimony and stuff like that. But I mean, you have to, I guess what I could do is we could look at potential trial dates and get those out to you. Like, it's not going to be July 10th, because unless we sever the two trials, there's no possibility of that.
Yeah, I'm not in favor of severing. If you want something, I'm happy to.
What I will do is I will get you, we don't have to wait until August 2nd for me to give you a trial date, but Ms. McDaniels doesn't even have a lawyer right now. So I can't really, can't be too aggressive there.
Didn't we set a trial date in October?
Did I give you a date?
No.
I don't think so.
I'm sorry.
No.
It sounds like, I mean, I think the court knew I was probably about to start speaking about bond, given that there's really a situation where
you're welcome to
waiting.
And if you need to put it on the record, and your client is listening, and you've done a fine job, but I've already kind of told you my fear in this case.
Well, I guess it sounded, what I heard the court's language was sort of type of language that would have denied such a bond motion.
I don't see an argument to be made now that bond would be appropriate. So I'm sorry, Mr. Whitsett. I know that's not good news for you, but my worry is that, again,
now that, may I speak for a second, please? I haven't had a chance to say nothing about nothing. I've been saying
you did last Wednesday, actually. So go ahead.
So like I was saying, I've been sitting here almost 3 years. You mentioned something about a flight risk. I don't have no absconding, no previous history of ever running. There's nothing to say that I ever ran or something to accuse one of flight, unless you've got a history of flight risk. And to say that I'm a danger to public or in danger to the public is, again, that's theory, because if you look at my record, I have no violent convictions or ever accused of anything violent until it's vulnerable situation at hand.
So, Mr. Whitsett, you make good points about yourself. Like, I'm not even denying that. I'm not angry. I'm not yelling at you, but you have to look at it from my point of view. You're accused of sexually assaulting a minor child. So I don't know how that you don't say that that's the accusation is potentially a violent or a terrible thing. I don't know if you did it or not. Like, I have no idea. I don't know what the evidence is going to show. I know, but, and then the other question is flight risk. Presumably, you don't have a history of absconding. I'm not denying that either. But what makes your case unique in my consideration is that the other trial went first. There were convictions in that of your co-defendant in this trial, and the other conviction of a similar story, if you will, to what you're being accused of. I have no idea if you did this or didn't do it. I know you've told me that you didn't do it. I get that. And luckily, I get to leave it up to the jury to find out, to determine this. But when I look at letting you out on bond or some sort of restriction or something like that, you've correctly identified. Are you a threat to society? Well, if you did what it's alleged that you did, you sure are.
But that's
And if I out knowing that your co-defendant is essentially going to serve 25 to 50 years in prison, and if you are likewise convicted, you're looking potentially at life in prison. So I'm just saying, like, there's all that would worry me about releasing you right now. So from an abundance
as well, Your Honor. I'm on parole.
I am not going to grant you pretrial release in this matter.
I get it. That's your choice, Your Honor. That's your choice. I get it. But I feel that this is just wrong, Your Honor. I'm being accused of something, and there's no evidence based on anything. There's only allegations. On a preliminary exam, the alleged victim, Miss Jalela McDaniels, stated on the stand that never sexually ever happened between me and her. What they may be accused of, that's their issue. That's not
every defendant only has allegations until their conviction. So the fact is, you're no different than any other defendant who's in custody proclaiming their innocence. And I'm not saying you're wrong in doing that, but I don't know yet. I know it's been delayed. I'm sorry it's been delayed. And if we could have done 3 juries, we would have tried to do that, but we couldn't do it. So now your trial would have started today, and you would have had a decision on this probably by the end of the week. But we have to delay it. Your lawyer brought up a very strong defense, and in fact, he won that motion, if you want to call it a win and a loss. But that's one of the reasons we have to delay this, is because there are steps and processes that have to happen to protect your rights and to protect the rights of the people. And so my only job in this is to be the protector of those rights, because I don't decide whether you're guilty or innocent. So that's my job, is to do this.
Right.
So that's all I can do for you right now.
You refuse me bond because you're saying that.
Okay, you're right. I did, and we're not arguing about it anymore.
What? Because the severity of the case, not because that you just said that.
I've explained it to you, Mr. Whitsett. You're not going to persuade me otherwise.
You're right.
I wish that I could do something different. I could feel comfortable in doing it, but I don't think I can.
You're right, Your Honor. Yeah, you're right. I understand. You have a good day, and I appreciate everything.
Okay.
Just for the record, Your Honor, just 3 things regarding the issue of bond. There was preliminary exam transcript. There has been a trial on the co-defendant. So it's the people's position that the likelihood of conviction is very high. There is a mandatory prison sentence. The defendant was on parole at the time of this offense, and he most recently was charged with assault with a dangerous weapon and possession of a weapon in the jail while confined in the Washington County Jail.
All of which I'm aware of, so I appreciate you putting that on the record. But
I mean,
again, but that's not even that. Like, there might, if there was a way for me to be assured that this wasn't going to be a potential flight risk, i.e. that additional information, but also, this is too complicated a case. I'm sorry for the delay, but that
can't make sense. You don't even. It's been
all right. Thank you.
3.5 years.
I appreciate the court's consideration this morning with the legal arguments.
So are we going to come back with Ms. McDaniel on August 2nd and then get a trial date?
I'm going to try to give you a trial date, or at least a date. I mean, what I'll do in the coming days is look at, like, again, September, October, see if there's a likely week that we could do the double jury. Again, she's not on the hearing any longer and doesn't have a lawyer right now. So depending on how quickly we get a lawyer appointed, that's a bit of a tall order to sort of think, like, in 6 weeks you're going for your trial here. But I am aware, Mr. Bernstein, of the delay for your client, and I do want to have this done as soon as possible. So
I can make myself available any date in October, Your Honor.
All right. Well, I'll see what I have available. I mean, I know I've got a 2-week criminal trial scheduled right now for the number of witnesses that are currently scheduled, but let's see what we can do. We'll see what we can juggle in terms of priority. And if I can give you a preliminary read on, like, hey, this week is going to be the best, at least I'll know from the 2 of you that it works. And then I'll just say to the new lawyer, well, here you go. counsel.
Good to have you on board. All right, thank you.
Thank you.